Today is part 2 of the bases for contesting a will. My name is Gregory Singleton. I'm an estate planning and probate attorney in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It sure helps support the video. So last video, we looked at the statutory bases for challenging a will. Today, we're going to look at the non-statutory bases, and we're also going to take a quick look at what happens once you challenge a will if you succeed. One thing to note is that the non-statutory bases, there's some good ones and some bad ones, and we're going to talk about both of them. 3 specifically, and the first one we're going to talk about is promises. This is where someone was promised something that by the decedent, and the decedent either didn't make a will or didn't put it in the will. And the basis is I was promised this and I should be getting it even though it's not in the will. Now the reality is that this is not a valid basis. The will, if one exists, is going to control, and if there is no will, it's assumed that that was intentional and the intestacy statutes will control. 2 examples of this might be a son was promised a house by his parents. But the will was, or let's say a brother was promised a house by the parents, but the will was never changed. Or you could have a son or some other child took care of their parents, and for doing so and leaving their job to take care of their parents for the last 5 years of their life, they were promised $20,000 a year. Now, the decedent didn't make it the will or didn't change their will, therefore that promise does not exist. This is probably, I would say, the most common basis that I see for people wanting to challenge a will. Unfortunately, not very many people are going to take, attorneys are going to take these cases because there is no legal basis for it. The second basis for challenging a will that's not statutory is what I call the life partner situation. This is where 2 people live together for a long time, say 5, 10, 15, 20, 30 years. Maybe they had a kid together, but they never got around to getting married. So when one of the partners dies, the other partner says, I essentially was their spouse, I should get the spousal share of the estate, or everything should come to me. Now, in Minnesota, we don't have common law marriage. It's not something we have, and there's only a few states that actually have common law marriage. In Minnesota, if you have a life partner, even of 50 years with 3 children and grandchildren, it's still not a recognized relationship in Minnesota. So if you want to protect that, you can either get married or you can do your estate plan. And if you do your estate plan, you make sure that you specifically put in your partner as what you want them to have. Unfortunately, this, again, is not a basis for challenging a will. Now, the third basis for challenging a will is what I call just drafting errors. This is a blame the attorney situation. There's 2 kind of different situations here, and we'll talk about each of them. The first one is if there's a problem executing the will. Now, a will is required to be executed with witnesses, with notaries, with signatures, with testamentary capacity, etc. If the will, let's say, was executed, but they forgot to sign, have 2 witnesses, or the notary never got around to notarizing it, that will could be deemed invalid, and most likely will be deemed invalid by the courts. So you can challenge a will on that basis. The second basis for what I call drafting errors is when there's ambiguity in the will. This is where the will of the language could have 2 viable interpretations, where only one of which, of course, is going to favor the claimant. So an example of this I could see would be someone saying, I disinherit my children, but also elsewhere in the will saying, I give my child John the house. So you've got 2 situations, one where the child is being disinherited, the other where the child is getting a specific gift. So that obviously does not comport with itself, and you could have a will challenge on that basis. And those 2 are actually good bases for challenging a will. So now that we've talked about all the bases for challenging a will, and there are probably other ones out there, I just picked the most common ones that I've seen. What happens if you invalidate a will? That's a great question. You may challenge a will and you may not get anything out of it unless you're careful. So let's say there's two situations I could think of. One is if you invalidate a provision of the will. Let's say you're able to invalidate a specific gift given to some person. In that case, the gift might fall to the residue and be distributed out with the residue. Let's say instead of just a provision, you're able to invalidate the entire will. If you invalidate the entire will, one of two things is going to happen. The first one is you could go to a previously rescinded will. And now just follow me on this one for a minute. In most wills, let's say this is a second will, in the language of the will be a provision that says, I hereby rescind all previous wills and codicils in my name, etc., with fancy language. In that case, the new will is the instrument that invalidates all the previous wills. But if the new will itself is invalidated, that provision doesn't exist, and therefore we go to the previous will. Now, if there's another situation, if the will is invalidated, but the previous wills were revoked by either a separate instrument that is not invalidated, or let's say it was just destroyed and ripped up with intent to revoke the will. In that case, you might go to either a previous will, or you might go to the intestacy statutes. In that case, you would follow the statutes of who gets your stuff, such as your wife and your children, and etc., etc. So that's what's going to happen if you invalidate a will. So that's part two of bases that challenge a will. And today we talked, of course, about the non-statutory bases, and we talked about the what happens if you invalidate a will. If you like today's video, please feel free to like and subscribe below. It really helps with the YouTube and Google algorithms. If you have any questions, please feel free to answer them in the comments below. I'll try to get to them. Otherwise, until next time, this is Gregory Singleton with Signature Law.